which is being prepared as I speak. All right. All right, good evening, everyone, and welcome to the final round of the Scott Moot Court competition. As I speak. I'm Professor Rebecca Delfino, and I want to welcome you to this year's competition. Before we begin this evening, I want to briefly tell you a bit about the Scott Moot Court program and introduce our honored panel of distinguished judges. For more than 80 years, Loyola Law students have participated in the annual Scott Moot Court competition in the spirit of friendship towards a goal of highest excellence in appellate advocacy. Tonight, we will observe the final round of the Scott Moot Court competition for 2022. The Scott Moot Court Honors Program is named in honor of the second dean of the law school, the late Joseph Scott. It is an on-campus student-run administered moot court competition run by the Scott Moot Court Honors Program, comprised of graduating law students, third years, evening and day. The journey of these 4 competitors began last August when they enrolled in the appellate advocacy course, where they learned the basic skills of oral advocacy and appellate brief writing. In the spring semester of 2022, these students entered the Scott Moot Court competition and independently researched and wrote an appellate brief on a moot court program that was created by the Scott Moot Court Honors Board. That is the problem that you're going to hear argued this evening. In addition to preparing a brief, they also participated in multiple rounds of oral argument. Before tonight, there were 4 rounds of oral arguments, both in person and on Zoom. Tonight, we feature the top 4 competitors in the competition who are competing this evening for the award of Best Oralist. The top competitors from the competition this spring will also be invited to join the Scott Moot Court Honors Board for next year. The board not only administers this competition, it also provides members for Loyola's moot court teams who go out and compete against other law schools across the nation and the 3 major national moot court competitions that are held each year, including the National Moot Court Competition, the ABA National Moot Court Competition, and the National Criminal Procedure Moot Court Competition. Finally, before we begin and before I introduce our panelists, I just want you to keep one thing in mind while you are watching. What makes this program particularly special and unique in its law school experience for these students is it allows a law student to work on what I think are the 2 most important skills needed by every successful lawyer. First, the ability to clearly and persuasively write their ideas and their arguments. And secondly, to engage in an effective oral argument of the brief that they have written. There are a few other law school activities or experiences that provide a similar opportunity. While the problem that they are arguing tonight is fiction, nothing here that you're going to see is scripted. The advocacy skills displayed this evening are real world, and they're going to be terrific. Now, I want to take a couple of minutes and introduce our honored jurists. I am so pleased to introduce 3 amazing members of the California judiciary. First, Noel Wise, who is a judge of the Alameda Superior Court, currently serving as a pro tem in Division 7 of the 2nd District Court of Appeal. Judge Wise was born in New Jersey, but moved with her family to Modesto when she was in the 5th grade. Before her appointment to the Superior Court in 2014, she was a founding member of a law firm in Alameda. And previous to that, she served as in-house counsel for PG&E and counsel at Stoll Reeves. Before that, she was an assistant U.S. attorney at the U.S. Department of Justice and served as a law clerk to the Honorable Harry Lee Onstead at the Florida 4th District Court of Appeal. Wise holds a Master's of Science of Law degree from Stanford Law School, a Juris Doctor degree from Nova Southeastern University, and a bachelor's degree in science from the University of Nevada. Her resume also includes work as a panel mediator at the First District Court of Appeal, a teaching fellowship at Stanford Law School, and an adjunct professorship at UC Berkeley School of Law. In addition to that, Judge Wise has distinguished herself by writing for periodicals and other things such as the Atlantic Magazine, Time Magazine, and the Daily Journal and Daily Recorder. And we are very pleased that she has agreed to join us this evening. Welcome, Judge Wise. In addition to Judge Wise, we are joined by Justice Maria E. Stratton, who is an Associate Justice in the 2nd District Court of Appeal, Division 8. I will note that Justice Stratton will soon be elevated to serve in the PJ position of Division 8, and we're very excited for her for that elevation. Justice Stratton was born in Santa Monica and raised in San Diego. She graduated magna cum laude and Phi Beta Kappa from the University of California and received her law degree from the University of California, now Berkeley Law. She served as a law clerk to the United States District Judge Harry Pedersen at both the U.S. District Court before he was elevated and later at the United States Court of Appeal for the Ninth Circuit. After clerking, Judge Stratton worked as a deputy public defender at the Office of the Federal Public Defender for the Central District in Los Angeles, and she was also an associate at several law firms in Los Angeles, where she practiced in criminal and civil litigation for 10 years and acted as an associate partner and managing partner at those firms. In 1993, the United States Court of Appeals for the Ninth Circuit appointed Justice Stratton as the Federal Public Defender for the Central District of California, where she served in that capacity for 12 years. In 2005, Governor Arnold Schwarzenegger appointed Justice Stratton to the Los Angeles County Superior Court, where she served as Assistant Supervising Judge of the Mental Health Departments of the Criminal Division, Assistant Supervising Judge of the Van Nuys Courthouse, and Supervising Judge of the Probate Division. From 2006 to 2018, she tried over 60 civil and criminal cases to jury verdict and presided over hundreds of civil and bench trials. Justice Stratton is also active in bench and bar education. In 2018, Justice Stratton was appointed to the California Court of Appeal, Division 8. She is also currently a member of the Judicial Council's Probate Curriculum Advisory Committee, Indigent Defense Oversight Advisory Committee, and a former member of the Judicial Council's Task Force on Criminal Justice. Justice Stratton is also the recipient of numerous awards recognizing her contributions in the areas of pro bono and as well as for the Women's Law Association. She has been named one of the top 75 women litigators in California and one of the 100 most influential lawyers in California, and we are so pleased that she was able to join us this evening. Last but not least is our presiding justice for this evening. That is Justice Carl H. Moore, who is a Associate Justice in Division 5 of the California Court of Appeal, 2nd District. He has spent his entire career as a lawyer and judge in Los Angeles. He moved to Los Angeles after earning his BA from Swarthmore and his law degree from Yale Law School. He was born and raised in Chicago, Illinois. In 2013, he was appointed by Governor Brown to serve as a judge for the LA County Superior Court, where he presided in criminal and family law cases. In 2018, Governor Brown elevated Justice Moore to his associate justice position in Division 5. Justice Moore began his career as a law clerk to the Honorable Mariana Falzer of the United States District Court. And following his clerkship, he spent his first 5 years as a lawyer in public interest law at Holland Phillips. And then subsequently, he was appointed as a assistant U.S. attorney in the Central District of California, where he spent 6 years as a federal prosecutor, specializing in criminal cases involving security, financial insurance, telemarketing, and tax fraud. Between his two terms as a federal prosecutor, he was in-house litigation counsel at NBC, supervising the work of outside counsel in civil litigation matters. Immediately prior to his appointment to the bench, Justice Moore was a partner at Munger, Tolles, and Olson, where he handled a wide variety of cases for companies, often dealing in complex civil litigation in everything from manufacturing to the entertainment industry. We are so pleased that he could join us this evening and will be serving as the presiding justice for this oral argument. Without further ado, I now turn it over to our bailiff, who will announce the call of the court.
Oyez, 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 all persons having business before the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Welcome, everyone. We have one case on calendar today. It's John D. Petitioner versus the United States Respondent. And we have certified two issues. The first issue dealing with a voir dire issue on impanelment of the jury, and a second issue dealing with the statutory scheme 21 U.S.C. 841 subdivision A, and whether or not this court should recognize a good faith defense to a criminal prosecution under that statute. Before we get started, I'm going to ask counsel for the parties to introduce themselves. We'll start with the two lawyers representing the petitioner, Mr. D. And maybe we can do it in the order of the issues to be argued. So we'll start first with the introduction of Ms. Lemire.
Good evening, Chief Justice Aaron Lemire for Petitioner.
Good evening, Chief Justice. Jenna Wan on behalf of Petitioner.
And for the Respondent?
Good evening, Your Honors. Diego Magana for the Respondent on Issue 1.
Good evening, Your Honors. Daniel Clark for Respondent, the United States of America.
Okay, thank you, counsel. And we're ready to begin argument. We'll start with the voir dire issue. Ms. Lemire, and you and all counsel who will follow will each have 11 minutes to argue. I expect you to manage your own time and to stay within the confines of that 11 minutes. And you can begin when you're ready.
Chief Justice, Associate Justices, and may it please the court. My name is Aaron Lemire, and I represent Petitioner Dr. John D. Today, I will be addressing the voir dire issue, while my co-counsel, Ms. Jenna Wan, will be addressing the Controlled Substance Act good faith defense issue. We live in a country founded with a constitution that guarantees each and every one of us an individual right to a fair trial by way of an impartial jury. Fairness is a core principle holding up our criminal justice system, and without it, public opinion will fall and the system will crumble. Here, the trial court failed to protect Dr. D's constitutional right to a fair trial by an impartial jury when it limited voir dire so severely that there was no reasonable assurance that juror prejudice would be discovered. As such, Petitioner requests that this court reverse the 13th Circuit because the trial court failed to conduct individualized questioning of the veneer to determine the effect of the exposure of prejudicial pretrial media had on jurors' state of mind. And so, Your Honors, this evening, the rule Petitioner is proposing the court adopt is that of Patriarcha. And Patriarcha is a First Circuit case that stands for the proposition that in a case such as this one, where there is pretrial media, a trial court must first make a determination as to whether there is a significant possibility that jurors have been exposed to potentially prejudicial material. And on request of counsel, the court then proceed to examine each prospective juror individually to elicit the effect of such exposure on the juror's state of mind. And Your Honors, this rule—
Counsel, can I interrupt you? This is Justice Stratton. Didn't the Court of Appeal adopt the Patriarcha standard?
Your Honor, yes. So the 13th Circuit did say the trial court followed it. However, based on the rule of Patriarcha and based on the facts of the case, the trial court, in fact, did not provide a reasonable assurance to that prejudice would be discovered here. For example, if we look at record site 6, the court simply asked a cursory yes or no question as to whether the prospective jurors had been exposed to the media. And once the court realized, yes, all the potential jurors had been exposed, that's when the line of questioning stopped. And defense counsel then asked the court to ask more pointed questions to determine prejudice. And the court said, no. We can look at record site 27 through 28. The defense counsel requested a questionnaire to be sent out to the jurors to determine prejudice. But that was refused by the trial counsel. And Your Honors, 5 other circuits support this rule in Patriarcha, that where there's a showing that there's adverse publicity, that
Ms. Lemaire, I don't want to get into circuit counting, right? I mean, you would agree this is not a game of numbers. I mean, the question is whether or not the 11th Circuit, which has gone differently on this issue, has done something that's more faithful to the rule of law. So why is it that we should reject the what they have done?
Chief Justice Moore, this court should reject the 13th Circuit's and reverse the 13th Circuit's decision, because this court in Skilling put forth several factors that courts should consider when looking at cases involving pretrial media and whether or not that media rises to the level of being inflammatory and thus prejudicial to a criminal defendant. And here, there was the pretrial media was inflammatory. This court in Shepard held that when the news focuses on a defendant's wrongdoing, it's prejudicial in nature. And this court talked about in Janko that alleged improprieties can be considered inflammatory. And in that case, when the media called a former convict, the criminal defendant, a former convict in the media and alleged to be a former employee of a racketeer boss, that was prejudicial. Here, if we look at record site 9, the Malibu mayor herself tweeted out to her constituents, to prospective jurors, insinuating Dr. D's guilt. And on record site 10, the Malibu News article
Did your client seek a change of venue prior to the trial?
No, Your Honor.
How should that impact our assessment of your burden to show us that what happened here resulted in an unfair trial, given that there was not even an effort to move to a different locality?
Your Honor, it should not impact the analysis. This court in Shepard instilled a general duty onto trial court judges to protect defendants from inherently prejudicial publicity that saturates the community. So it was the role of the judge.
But the record here, doesn't the record here reflect that the publicity, which maybe saturated the community, was mixed? In other words, it included his social media accounts. He's a celebrity. He has a following. So where we have mixed media and it's not all prejudicial, doesn't that sort of indicate maybe a strategic reason why there wasn't an effort to change venue? And we should look really carefully at this rather than rewarding this with a reversal after trial?
No, Your Honor, I do not believe so, because no court has limited prejudice to cases only involving negative media. The key question here is whether or not the pretrial media had an effect on the jurors' state of mind as to render them no longer impartial. And if we look at US v. Orlando, it's instructive there. The court there found that the media was not prejudiced because it was not particularly inflammatory. The coverage there only ran the gamut of defending to praising to simply reporting on defendant's situation. And because there was no particularly inflammatory piece of coverage there, that's why it wasn't found prejudicial. Here, yes, I agree. There are two social media posts in the record on record site 8 and 9 showing support for Dr. D, but because of the negative coverage, it's still inflammatory and it's still prejudicial.
Counsel, and it wasn't really the issue here that you wanted to have a questionnaire, a juror questionnaire. And while that can certainly be a useful tool, at the end of the day, didn't the judge permit there to be a full questioning? There really wasn't anything that counsel wasn't permitted to ask to suss out whether there was really this prejudice.
No, Your Honor, that's actually incorrect. The trial court limited the defense counsel's questioning to only targeted questions revolving around the facts of the case. The court on record site 6 denied defense counsel the opportunity to ask questions to probe prospective jurors whether or not they had prejudice or biases. So the court did not allow defense counsel to do that. Additionally, Your Honors, the jurors here in this case were judges of their own impartiality, which is not permitted because the court only asked cursory yes or no questions and did not ask questions or submit a questionnaire to probe whether or not there was prejudice. The jurors were in fact judges of their own impartiality, which the Fifth Circuit has held is reversible error when it allows jurors to make that determination on their own.
I'd like to ask a question on a slightly different topic, which is the relationship between this court and the trial court on issues of voir dire. You would concede that we're talking about an abuse of discretion standard here. Is that right?
Your Honor, I would not concede that. I argue this is an issue of constitutionality and whether
So if it's an issue that's rooted in constitutionality, the Patriarcha decision that you're citing to is not really rooted in that. It's rooted in a notion of the supervisory powers of an appellate court and how that should, in Patriarcha, that we should use those supervisory powers to ensure a fair trial, but it's not really rooted in any constitutional principles. And I question whether or not that's a correct way for us to relate to our trial court. I mean, isn't the trial court, who sits in the jurisdiction where this trial took place, in the best position to assess what the local publicity is like and how it might affect the jury pool that trial court deals with day in and day out? Why should we second guess that?
Your Honor, I see my time has expired. May I briefly answer your question?
Yeah, please answer the question.
So, Your Honor, yes, I agree that the trial courts are given an immense amount of discretion. However, if this court is so inclined to view or have the standard view of abuse of discretion, the facts here indicate that the court did abuse its discretion. And Your Honor, for those reasons, I ask this court to reverse. Thank you.
You're muted, Chief Justice.
I apologize. We now are going to hear from the respondent on the voir dire issue. So, Mr. Magana. You can proceed. Go ahead.
Mr. Chief Justice, and may it please the court. My name is Diego Magana, and I rise on behalf of the respondent. Your Honors, today I will address why the trial court did not err when conducting voir dire. My co-counsel, Daniel Clark, will address the jury instruction issue. Your Honors, This case is about unfavorable results. Here, the petitioner is asking this court to reverse his conviction based on a largely factual accounting of his role in the death of his patient. Your Honors, here the trial court should be affirmed for the following two reasons. First, the trial court did not have an obligation to conduct a patriarchal style of questioning. And second, even if the trial court did err in refusing to further question potential jurors, it is still a harmless error because the information that the jurors were exposed to was not inflammatory in nature. Before addressing each of these points, respondent would like to clarify the standard of review for this court. As Justice Moore pointed out, the correct standard of review in this case is abuse of discretion. Your Honors, this court in Connors versus United States stated that voir dire is well within the discretion of the trial court, and as such, great deference should be given to them. This court echoed that very opinion in both Moot versus Virginia and Skilling versus United States. There, this court held that trial courts are in the best position to measure impartiality of jurors. And this brings me to the very first point, Your Honors, that the trial court did not have an obligation to conduct the petitioner's specific type of questioning. Your Honors, first.
Oh, counsel, can I just interrupt you? Tell me your understanding of what the rule is. What is the obligation of the trial court? Because I have a rule that was set down in the Tetsy's case from the 11th Circuit, and I'm wondering if that's the rule that you are adopting as well, which is a reasonable assurance the prejudice of the jurors would be discovered if it was present. Is that the rule that you are pushing today?
Yes, Your Honor. And that it's that specific rule in conjunction with the patriarchal standard that petitioner is asking for. So, so
then I guess my next question is, tell me exactly how this judge could have had a reasonable assurance that these jurors weren't prejudiced when they weren't even asked if they were prejudiced or in any way affected by the media that they all saw. How can we say that the judge guaranteed or had a reasonable assurance that there was no prejudice?
Your Honor, page 6 of the record indicates that the court took a two-part approach to questioning jurors. First, the trial court asked cursory questions, yes or no, as to whether the specific juror was exposed to any pretrial publicity. Second, Your Honor, the trial court did engage in substantive questioning about what jurors were aware of. It was only after this substantive questioning that the trial court believed that it's in its discretion what the jurors were exposed to was simply not inflammatory in nature. So
and how do we know that? Because the judge didn't make any findings.
Your Honor, the findings come in the way that the judge proceeded with voir dire. In light of the petitioner's request for a specific questionnaire, the trial court decided that it was insufficient based on the answers that he heard during voir dire. Your Honors, and this goes to that very first point, that there is simply no constitutional obligation by a trial court to engage in this type of individualized and specialized questioning.
Wait a minute, but isn't that what Patriarcha said the rule was? That's how you do it?
No, Your Honor. The First Circuit in Patriarcha states that there are two conditions for a court to continue this type of individualized review. First, it's when it's in the trial court's opinion to do so. And second, on the motion of defense counsel. And here, Your Honors, we do not have this satisfaction of both those requisites. Here, after the trial court did this substantive questioning, it decided that the answers were sufficient to continue with voir dire. Your Honors, as stated previously, there is no constitutional mandate by this court to conduct this questioning. This court said it best in Irving versus Dow.
Well, even if it's sort of a practical reality that we're trying to determine from the record, there are limits. You admit there are cases out there where pretrial publicity could escape sufficient analysis by a trial judge. Will you at least grant me that?
Yes, Your Honor.
So we're trying to figure out, even if it's not constitutional, whether or not there was error here. And wouldn't you also concede that there's really a difference between asking these kinds of questions on a questionnaire or asking them in a proceeding where each juror is questioned individually than in a case like this where there's only cursory questions asked in open court? And one of the reasons that's very different is counsel for someone like Dr. D may be very reluctant to have jurors speaking about specific facts they knew in a way that's going to be prejudicial to their client in open court. By depriving them of these mechanisms of individual inquiry, doesn't that raise for us a real practical problem, setting aside whether or not you think it's constitutional or not, about whether or not we can have any assurance that this kind of voir dire would surface the sorts of biases and prejudices that really should result in a reversal of the verdict?
Your Honor, to that specific point, the trial court has an obligation to grant a defendant a fair trial. Here, the actions that it took was sufficient to meet that burden. Now, when it comes to the specific tactics of counsel and how they go about making the decisions of which jurors to dismiss and to what specific arguments is best for their client, the trial court does not have an obligation to respect that. It is simply these essential demands of fairness that the Constitution instills upon trial courts. And moreover, Your Honor, to a bigger point, this court has recognized that trial courts are in the best position to make decisions about juror impartiality. This court in U.S. versus Skilling states that the trial court's discretion is at its pinnacle when conducting voir dire. And Your Honor, even if this trial court did make an error by not questioning the jurors more detailed, it's still
I'm sorry. In
sorry,
Skilling,
I think you were muted if you asked a question, Your Honor.
I did, and I apologize. I keep doing that.
Sorry.
In Skilling, didn't the trial judge use a questionnaire?
Yes, Your Honor.
Are there any cases you can point to where they both did not use a questionnaire and then restricted the ability of counsel to inquire in detail about the prejudice that might have been caused by media exposure?
No, Your Honor. And while the Fourth Circuit's opinion in U.S. versus Pomponio does relate to this question, there is simply no case in which a trial court both denied the type of questioning and didn't conduct the individualized questioning themselves. However, Your Honor, even if that is an error, it is still harmless on appeal because here the petitioner cannot show that there was actual prejudice among the jurors. Your Honors,
you mentioned this at the beginning, and it's a bit of a chicken and an egg problem because how is counsel going to be able to establish that if they weren't able to ask the questions? I mean, how do we know?
Your Honors, we can do so by looking at the record. And the record indicates various instances of the pretrial publicity that the petitioner is asking damages a juror's ability to remain impartial. And looking at the record as a whole, at what the petitioner brought on appeal, it is simply insufficient information to be considered prejudicial or inflammatory, as the petitioner states. Your Honors, there are two.
So let me get it straight, Mr. Magana. The government's position is that it didn't even rise to the level of asking more questions. That's basically what you're saying?
Yes, Your Honor. The trial court's discretion here applied, and they believed, being in the best position to do so, that further questioning was not necessary.
And so what do you think would have triggered more questioning? What would have the pretrial publicity had to say in order for the more questioning to be triggered?
Your Honor, this court answered that question in Skilling versus United States. And there they mentioned that the nature of the publicity is really what the court should look at. Some examples of something that is extremely prejudicial and warrants a court asking questions can be found in Rideau versus State of Louisiana, where we had a confession from a criminal defendant aired on live TV, and the First Circuit's opinion in US versus Sarnaev that involved the Boston Marathon bombings. It is in situations where it is more likely than not, and there is evidence to prove that jurors simply cannot make a detached and neutral opinion about the case. And we don't have that.
I know that's okay. This may be a really hard question because I'm having trouble even thinking of an answer. Is what would your bright line rule be?
Mr. Chief Justice, I see that my time has expired. May I briefly answer and conclude?
Yes, please answer Justice Stratton's question.
Your Honor, the bright line rule would be that when a petitioner brings specific instances of potential prejudice, that a trial court should look at that and then make a determination as to whether jurors can remain impartial. Absent defense counsel bringing these specific instances and the judge looking at them to determine whether they will damage the impartiality of a juror, the trial court should retain its discretion in conducting voir dire. Thank you, Your Honors.
Thank you, Mr. Magana. We will now move on to issue number 2, which is the good faith defense issue, and we'll start with Petitioner's Counsel, Ms. Wan. You can begin when you're ready, Ms. Wan.
Good evening, Chief Justice, Associate Justices, and may it please the court. My name is Jenna Wan, and I will be addressing the good faith defense issue today. The Controlled Substances Act was created to criminalize pill-pushing doctors, but not doctors like John D., known for his thorough and thoughtful patient care and significant contributions to the medical field. Today, especially considering the pandemic, our nation's ability to handle unforeseen crisis depends on our capacity and discretion of medical professionals. Yet the 13th Circuit is using the Controlled Substances Act to tie the hands of doctors who were never meant to be targeted by this statute. Thus, petitioner requests that this court reverse his conviction. The trial court erred in omitting the good faith defense from the jury instructions, which our legislation and courts intended to shield medical professionals from criminal liability. On the record on page 6, it can be seen that the trial court refused to recognize the good faith defense simply because it was not prior recognized in the jurisdiction, ignoring that this overwhelming majority of circuits have recognized it, including the 2nd, 4th, 5th, 6th, 7th, 9th, and 10th. However,
Ms. Vaughn, this is Justice Stratton. I'm sorry to interrupt you, but I think when I reviewed the record, I didn't see any evidence of good faith necessarily. And it appeared that the trial judge, or at least the Court of Appeal, didn't think the evidence warranted a good faith instruction. Can you just recite for me quickly what facts you think there are in the record that support a good faith defense?
yes. Your Honor, for example, on page 21, on defendant's testimony for the trial court, he explained that he consulted medical guidelines for dosages and would remind Ms. Woods of the side effects. And this is also evidenced on page 12 of the record with the medication schedule, which was very thorough and meant to avoid overdosing and side effects. Only a doctor who wanted to protect his patients and had a purpose when prescribing these medications would have drafted such a schedule. And that is only one piece of evidence that would evidence Dr. D's good faith. Jury instructions as a whole, yes.
There are a couple varieties of a good faith defense. There's one that is subjective. Did your client, or does a doctor, believe personally that they were meeting the medical standard of care and acting in good faith. And there's an objective standard. Are you arguing for one or the other?
No, Your Honor. Actually, petitioner calls for a more general good faith analysis that exempts physicians that show either subjective or objective good faith, that they were acting as doctors and not violating the law.
The evidence that you pointed to, his testimony, at least suggests to me, in response to Justice Stratton's question, that what you may have here is subjective good faith. But isn't that a rather dangerous rule to adopt? When you have a doctor like this, it points out somebody who believes they're sort of a super doctor, who's prescribing medication even before it's necessary, preemptive prescriptions of medication. That seems to point out a real danger if just someone subjectively believes they're such a special and good doctor that we ought to let them off the hook. Could you comment on that? And at a minimum, shouldn't we be applying some sort of objective standard here, whether or not they acted reasonably as other doctors would?
2 points in response to that, Your Honor. Firstly, there is also reason to believe that Dr. D had objective good faith, in the sense that he only prescribed in response to when his patients would come to him describing pain, and that he relied on the AMA handbook and CDC guidelines, which is what a reasonable doctor would do if he did have to prescribe opioid medication. And the second point, there is a danger in only recognizing objective efforts and ignoring subjective efforts. As outlined in United States versus Kahn in the 10th Circuit, if only an objective standard applies, a pharmacist who unknowingly filled an invalid prescription would be liable, even if it was filled within his scope of professional practice. The refusal to recognize good faith on either level goes beyond even Dr. D's case, because it will endanger and chill medical professionals across the nation. Thus, the instructions at Dr. D's trial were not accurate to the law and deeply prejudicial. Jury instructions as a whole must be reviewed de novo to determine whether they accurately state the law or unfairly prejudice the objecting party. And as seen on the record on page 31, the instructions given at trial instructed the jury to convict Dr. D if he knowingly or intentionally prescribed outside the scope of professional practice. However, there was no allusion to his good faith nor the legitimate medical purpose prong of the offense, which our circuits have decided must give consideration to a doctor's subjective intent in treating his patients. Furthermore, the policy established by this court in United States versus Moore analyzed legislative intent behind the statutes and established that the goal was to punish medical professionals who act as street pushers with no claim to legitimacy. Furthermore, in Gonzalez versus Reich, this court also saw that there is a beneficial need for controlled substances in the context of the medical profession. The regulatory scheme was designed to foster this beneficial use when a physician sees a legitimate medical purpose necessary to maintain the health and general welfare of the people. It is also noted that in this case, while it regarded the use of medical marijuana, this court saw that there could be a use for a medical use, especially when a physician only prescribed it believing that without it, his patient would suffer from excruciating pain. This is analogous to Dr. D, who is shown on the record on pages 4 and 21 that he only prescribed opioids to end his patient's pain. The good faith defense emerged from these concerns of public health and of wrongly criminalizing well-intentioned physicians. However, by omitting any allusion to a physician's subjective intentions, a jury would be instructed to convict a doctor based on acts of, yes.
I'm glad you mentioned the jury because I wanted to ask something about that. We do have jurors here who did convict this doctor. And while some of what you're reciting, I think, is evidence in the record, there's countervailing evidence too. I mean, another way to look at this record is you have a doctor not acting as a doctor, but a doctor letting the patient be the doctor. Every time this victim came in, she was given a new medication. She was given medications when she didn't come in, and she was given, again, medications that were preemptively given when the doctor figured she might come in. So even under an objective standard, that just seems way out of bounds of what we would normally think of happens in medical practice, where before prescribing anything, the doctor sees the patient, evaluates the patient, and also then monitors what's happening with the patient. Doesn't disappear from the patient in terms of actual checkups and start just prescribing things in an anticipatory way.
Your Honor, the fact that you point out that there is conflicting evidence that Dr. D may or may not have had good faith is even more reason that the jury should have been instructed, because this would have been a finding of fact for the jury to decide. Because the jury also had to have known this, because even though Dr. D may have had made mistakes, good faith also precludes and negates a finding of knowledge or intent, which would uphold the basic principle in United States versus Rehab that injury is only criminal if inflicted knowingly. And
let me just stop you there for a moment. I mean, it sounds to me like what you're saying is you would agree that you can't qualify for this good faith defense as a physician if you intentionally fell outside the usual course of professional conduct. Is that fair? Do you agree with that?
Yes, specifically, you would not qualify if the evidence overwhelmingly shows that you intended to violate this law in dispensing pills. Or
okay, what about, hold on. What about if you were reckless?
The statute is silent as to recklessness as a form of mens rea. And so while the statute is silent to that, we should not be over-inclusive and convicting practitioners who show signs of recklessness simply because there isn't a lower statute that fits their conduct better. But comparatively, Dr. D was not as culpable as past defendants who have been charged with this offense, who have evidence that they knew their patients were addicts or selling, or were charged with conspiring with others for drug trafficking. Convicting Dr. D will not serve the legislative purpose to punish street pushers. It will instead chill practitioners from engaging in medically feasible treatments and instill a fear of criminal liability for acts of malpractice. Your Honors, for those reasons, we respectfully ask that you reverse Dr. D's conviction. Thank you.
Thank you, Ms. Wan. And we will now hear from the government, Mr. Clark. You can begin when you're ready.
Thank you, Chief Justice, Associate Justices, and may it please the court. Daniel Clark on behalf of the respondent, the United States of America. When the victim, Shailene Woods, died, she was found with over 40 bottles of fentanyl and other dangerous narcotics, all of them prescribed by her doctor, Petitioner John D. Petitioner has a history of overprescribing dangerous drugs and causing overdoses, a history of turning healthy patients into drug addicts, and a history of putting drugs into the hands of street pushers. Section 841 criminalizes doctors who knowingly or intentionally prescribe controlled substances outside the usual course of professional practice. Petitioner was convicted under Section 841, and now he contends that his conviction ought to be overturned because his jury wasn't given this sweeping jury instruction that would have required an acquittal simply because he thought he was doing the right thing. This court should reject that contention for 4 reasons. First, the district court rightly refused to give Petitioner's proposed instruction because that instruction misstates the law and goes beyond any good faith instruction to a Section 841 charge ever upheld by a federal court. Second, this court need not recognize a good faith defense in the first place because the district court's given instruction is a perfect example of how to articulate Section 841 without using the words good faith.
Tell me how.
So the district court gave a very succinct, very cogent instruction to the jury that you must convict only if you have found beyond a reasonable doubt that petitioner had intentionally or knowingly prescribed a controlled substance outside the usual course of professional practice. And that tracks the language of the statute itself. The CSA doesn't use the words good faith. It's simply—
Okay, so counsel, what if he's just really stupid? Like he's a really stupid doctor. How does, so, I mean, he's obviously acting outside the course of medical practice because he's making stupid decisions as opposed to evil decisions or decisions based on greed or any other bad reason. If he's just like a really stupid doctor, is he still criminally liable under the statute?
Your Honor, I think we're in the realm of hypotheticals because such a doctor might not even be registered with the FDA or should not be. But if he were registered and he was acting completely outside of the bounds of the normal practice of medicine, and he's doing so intentionally or knowingly. Remember, mens rea for knowledge doesn't mean it has to do it purposefully, but he has to have a reasonable degree of certainty that he's doing so outside the usual course of professional practice. And if he's got that mens rea, then he must be convicted here.
But don't we really want more here, though? I mean, this whole area of physician liability goes back to United States versus Moore, a 1975 case. And haven't we traveled awfully far from that? In that case, they were talking about prosecuting a physician who was involved in a large-scale drug operation. There were some 800,000 pills dispensed. He was charging money for the medication rather than for the medical care. He was clearly a drug pusher. And all Moore, the U.S. versus Moore says is, look, just because you're a physician who can dispense medications legally, we're not going to exempt you from prosecution under the statute. And now we travel to this kind of case today, whereas as Justice Stratton was just inquiring, here's a doctor that maybe just did a bad job of being a doctor. Why should that bring him into the criminal arena?
Well, Your Honor, you are making a very astute questioning of how far Moore is apart from this case. And I think part of the reason why there's confusion in the circuit is that circuits have read more into Moore than necessary, than what this court was trying to do. Just because there was a jury instruction that included the words good faith doesn't mean the court expressly condoned or recognized a good faith defense to Section 841. And if you're looking at the crisis that we have in opioids today, there needs to be stronger, more stringent enforcement of our drug laws because so many people are dying because of opioid overdoses.
Well, I'm sorry, counsel, that doesn't cut it for me, because it's one thing if you're talking about civil liability and suing a doctor for malpractice or negligence or whatever, but you're talking about criminal liability under a statute that says knowingly and intentionally. And I am still troubled by not the Moore case, because there you had a doctor that was knowingly and apparently knowingly and intentionally pushing drugs without a medical reason. Here you arguably have a doctor who's could be stupid, he could be negligent, he could be reckless even, but he could have been acting in good faith maybe.
Well, Your Honor,
why shouldn't the jury be allowed to make that decision?
Your Honor, with due respect, the jury did make that decision by looking towards the district court's instructions, which included the mens rea, intention, and knowledge. And it was a very succinct articulation of the law where the criminal elements were very close to the mens rea elements, some 6 words separated apart. A jury looked at the evidence in this case and unanimously convicted Petitioner for knowing or intentionally prescribing a controlled substance outside the usual course of medical practice. And the evidence here is highly egregious. You have a doctor who was routinely prescribing dangerous narcotics to repeat addicts and to drug dealers. On page 19 of the record, his own patient testified that he was giving prescriptions out like candy. And page 12 of the record has his schedule, the drug schedule he gave to victim Woods, that showed that he was not only prescribing her opioids and benzodiazepines in combination, which the CDC guideline says never to do. He was giving them in large quantities. At any given time, he was prescribing her 4 varieties of opioids and 2 varieties of benzodiazepines. And he was telling her, take as much as you need it without giving her a recommended dosage. That, to me and to the government, is not just mere stupidity. It's not just mere recklessness, but knowing or intentional disregard of the standards of the medical safety. And we're in the midst of an opioid crisis, Your Honor. I know courts do not make decisions based purely on policy, but a policy here is strong and it militates a strict enforcement of our drug laws. In just the last year alone.
So, counsel, I actually appreciate the policy argument you're trying to make, but I mean, isn't really the better policy, if it's going to come down to that, is, you know, regulate the drugs, check and see who's over prescribing these drugs and go after their licenses, right? Like, I mean, start to take other measures to be reactive and wait until somebody dies and then, you know, file a criminal action against them. It seems like that approach to this policy is very reactive and doesn't really get to the heart of the problem.
Your Honor, the policy and the realities of our country today requires a multi-pronged approach to the epidemic. And to your point, drug manufacturers have been strictly criminalized and prosecuted. It's the doctors that's doing a lot of the work in putting drugs out into the streets that are largely being refrained or protected from criminal liability, and that has to stop. If you're looking at the number of deaths here, it's over 100,000 per year, and it's getting worse. And the legislative intent behind the CSA is to put a stop to doctors who are doing that.
Mr. Clark, where we have a statute like this that's been on the books for some time, we were just talking about the Moore case back in 1975. Why should we give consideration to what's happening now in terms of the need for medication because of pandemics or because of problems in dispensing medications that we see in the opioid crisis, when what we're talking about is prosecution of an individual, and shouldn't our interpretation of this statute and what defenses are available to an individual defendant exist regardless of what decade they were prosecuted in? Why should Dr. D be penalized because we're concerned about a pandemic or we're concerned about the opioid crisis? Isn't the question whether this statute, which is a criminal statute, should be applied to an individual absent some showing of mens rea beyond the mens rea of stupidity, as Justice Stratton said?
I think that's a very good question, Your Honor. And you're right. You should not just look at the policy and what era we're in to determine how to interpret statutes. But this court's own precedent in Moore addresses that issue because it looked into the Congress's legislative intent behind the CSA, and it found that Congress, in enacting the CSA, wanted to strengthen the law and not weaken it. The predecessor law, the Harrison Act, already criminalized doctors who went beyond the usual course of professional practice. And Congress realized that a lot of the illegal drug trade came from doctors who were diverting prescription drugs to illegal channels. The facts of this case are particularly egregious, but the real tragedy is that it's happening across this nation on an everyday basis. Petitioner was convicted by a unanimous jury for 40 counts of violating Section 841, and on appeal, his contentions were flatly rejected by the 13th Circuit. This court should affirm on both the voir dire and the good faith instruction issues, because the upshot of this case is that Congress, the executive branch, and the lower courts have all agreed that serious steps need to be taken to rein in doctors that are directly contributing to the opioid the epidemic here. This court should uphold petitioner's conviction and not undo the justice already done. Thank you.
Thank you, Mr. Clark, and thank you to all counsel for your excellent argument. This court will now take some time away from the bench, and we'll be back in a little bit after we've had a chance to discuss the arguments.
All right, thank you, everyone. And as Chief Justice Moore said, they're going to take the matter under submission and go into a breakout room and deliberate. And in the meantime, we will wait patiently for their decision. All right, welcome back, everyone. Thank you for your patience. I have asked our three judges to give feedback to our oralists. So if I could have the oralists turn on their cameras. Before they begin, though, I do want to offer my sincere congratulations to all of you for such a fine oral argument this evening. I was so impressed at your competence and your poise and your thoughtfulness in responding to the panel's really tough questions. I mean, I was so glad I had my camera and sound off because I thought, oh my God, I couldn't answer the questions that were posed to you. And you all stood up to the challenge and you responded with fine skills that showed you are so ready to go out there and represent clients in front of the appellate courts. And so I was extremely impressed with what I saw. So now I'd like to turn it over to our panel and ask them to give you feedback. And then after that, we'll talk about the awards. So Chief Justice Moore, why don't you go ahead and go first?
Well, so we have an order that we're going to
Okay,
and rather than do it by each of us commenting on all four of you, we're going to take you one at a time in the order you argued. And Justice Wise, why don't you start with Ms. Lemaire and give some comments, and I'll follow up, and then Justice Stratton can finish her off at that point.
All right. Good evening, everyone. And Ms. Lemaire, although I'm going to start with you, I would be remiss if I didn't say to all of you, and I'm sure, I have no doubt in previous rounds that you have heard this, you did a fantastic job. All four of you were really, really very good. And you should feel incredibly proud of yourselves tonight for the work that you did. And I know it took a lot to get there. And to the people who have helped you along the way and your professors, everybody should feel very proud of that work. I certainly would be very happy to see any one of you in court as an advocate, of course. And so, Ms. Lemaire, I have the honor of being able to chat with you first. And I just want to say, I thought you did a really good job. And it's very difficult, I think, oftentimes to go first, because there's already some momentum that's happening when someone else has begun. And so I recognize that. And you just jumped right into it and seemed confident. Didn't seem like you were reading. It seemed like you had your ideas out there. And I thought that was terrific. Couple of sort of constructive things. At one point you were asked a question, I think it was from Justice Moore, where he used the words, which interpretation is more faithful? Every once in a while, I feel like a judge gives you a little bit of not a softball, but they give you something really juicy to work with. And it would have been nice in that instance, perhaps, to just take his words instead of saying, it was a good question, or not that you said that, but to say, well, let me tell you actually which interpretation is more faithful, and move on from there. I really appreciate that when I asked you a question, you did not say to me, with all due respect, Your Honor, you're wrong. I always feel like there's really very little respect that is in that, not always, but I like the fact that you felt confident enough, even right out of the box first, to just say, no, actually, that's not really the case. Let me tell you why in the record it was something different. So I thought you did a really nice job, and congratulations.
Thank you.
I would echo everything that Judge Wise just said. I also, this is part a super big compliment that's coming your way, and part a criticism myself, which is I got mixed up between the issues and I asked a sort of a nonsensical question right out of the box. And you just didn't let it faze you. And that is something that happens in argument, is you'll get questions sometimes that just kind of, the question misses the boat. And you want to be responsive to whoever's asking you the question, but sometimes there's not much you can do with something. So I thought you were super effective throughout your argument. You didn't let anything, including that sort of thing, get you off track. And you have a really nice conversational tone, which I find very effective in an advocate. Strong, but not sort of strident. And so don't lose that.
Thank you.
You're muted, Justice Stratton.
Okay, sorry. Erin, I would echo all of that. And I would add that I thought you had really good eye contact. And I know that that might not seem very important because we're all doing this by Zoom, but it's almost more important by Zoom because we're just seeing your face. And so in the courtroom, we see your whole body language, we see everything that's going on. But on Zoom, you just see your face. And the fact that you had really good eye contact, I think that was really great. It didn't look like you were reading your argument. And believe me, my last oral argument, 2 of the lawyers came in and just read it off their computer. And we knew they were reading it. And at that point, we just put our pens down because what are you going to do? You know, you were really, really conversational, and I thought you were engaging and good slow pace, not too fast. You didn't seem like you had a nerve in your body. You were so calm. It was just, you did exude this confidence that made me want to believe you, made me want to, you know, adopt what you were saying. I thought the fact that one of the first things out of your mouth was you said, "This is the rule I want." I love it when lawyers do that because then I know what they want and I know if I can give it to them or not. And so the fact that you said that right out of the box, I thought it really showed that you had a handle on what you were going for. I really liked that quite a bit. And I also liked it when you said, I think to Justice Wise, no, I'm not conceding that. But you said it in a nice enough way, you know, that but you just said it. You weren't afraid to say it. And I thought that was again, very good. You knew your record sites, and I just would welcome you in my court anytime.
Thank you so much.
All right. And then we'll move on to Mr. Magana and Justice Stratton. I think you were going to continue.
Okay, yeah. Mr. Magana, Diego, I also like the way you started out, which is, and there's 2 reasons why. It's so refreshing when the lawyers just come in and they say what they want. You'd be surprised how many lawyers don't do that. And so we're kind of, you know, unless we can get it from their brief, we're kind of fishing around trying to figure out, well, what is the rule you want us to say, or how do you want us to go? So I thought that was really great that you started out, well, there's 2 reasons why, and these are the 2 reasons. I thought you had a really good handle on the cases and on skilling. You kind of just seamlessly kind of went into that. I would say that you 2 had a very good pace. None of you guys had any like nerve issues. It seemed like you were very like calm, and you had your eye contact down, and I thought that was really great. One thing I would say to both of you, Erin and Diego, and I'm going to say it to Jenna too, I personally think, because I used to represent individuals, I think you should say who you were representing. When you make your appearance, hi, I'm, you know, Erin Lemire, and I'm here for Dr. D, you know. Daniel did it when he said, I'm here for the United States of America. You know, I just think it's, that's what we do as lawyers, right? We're here for somebody else. So we should mention them. We should respect them. And we should make sure that the judges know I'm here for a person, or I'm here for a particular client, so that, you know, we get it, that you're really engaged with what you're doing for your client. You're a real advocate. So I just like point that out to you as something to maybe add to your toolbox.
Justice Wise?
You're muted.
I have a colleague who had a gigantic mug that said, "You're muted" on the back, and they would just hold it up. It's probably not a bad thing to have even now. I agree with everything that has been said. So I'm curious. I mean, so again, so impressed with what all of you were able to do. In the previous rounds, did both people go on the petitioner side before they went to the respondent side? No, it went back and forth, issue to issue. And so one of the things that I would say it's the flip of what had been suggested, I think, of Justice Stratton. Is I thought you did a really great job of asking for what you wanted at the beginning. Don't forget to also do it at the end if you have a moment. So to kind of tidy it up there at the end and remind everybody what you're looking for. I thought you just seemed so calm and cool. You just seem like you've been doing this for a really long time, just very, very comfortable in your own skin, and a really great understanding of the record. So good job.
Yeah, I wanted to actually add the same thing, which is I thought you very effectively dealt with the record here. It's very easy on both of these issues to sort of get abstracted from the particulars of this case because the issues have broader implication. And there is a real question on this record factually, I think, whether there was this pretrial media coverage was something that was a terrible thing. I mean, there's enough in the record that I saw, at least going through it, to suggest that there was a lot of positive stuff, that this guy was somebody who was a media person and continued to be throughout the pretrial proceedings. And you very effectively used that as kind of the last line in the sand for you on this case, that even if we're going to find problems with the way the voir dire was conducted, well, what did it all amount to at the end of the day? And so you knew, as an advocate, it's important to know each of your, what's that bottom line thing where you can't concede, and you just don't. I mean, if the court is going to beat you up, but you know you can't give in on it, you got to dig in, and then you got to know where's the next point in the argument where you're going to draw the line, and you had all of those points very effectively in mind, which shows that you thought about your case and you did a good job of anticipating what we might ask, and you were ready for it. So very effective. So I guess I'm going to start now with, we're going to move on to Ms. Wan. I thought you did an excellent job. Very clear. And there was one particular moment where I got into sort of debating with you on the issue of subjective and reasonably objective good faith. All of the evidence on this record to suggest that you could really reach a decision to say there was no good faith here. I think there's a lot of really problematic things that Dr. D did. And you turned that around on me in an instant with your argument that, yes, you've cited all of the very effective, all the very important evidence on the record to show that he did not act in good faith. And I've cited to you all the evidence that he did act in good faith. That's a fact. I mean, you said it better than I'm saying it, but that's a factual dispute that goes to a jury. That was a winning argument. I mean, that's a signature moment winning argument where it's like, okay, you just won the argument and completely backed me down. It was the perfect thing to say and said perfectly. So you'll have these moments sometimes in argument where you get a chance to really make your point. And sometimes it comes by turning it on the judge who's asking the question. And those are always fun, and you should never forget them. So don't ever forget that one. That was excellent. Justice Stratton.
You know what? I noticed that as well, and I actually wrote it down because when you made that answer, I was just like, "Oh my God, she just won this!" It was such a great way the way you handled Justice Moore's question, in so few words, but you just kind of nailed it. And I wrote it down and wrote all kinds of exclamation points on my little notes. I thought you had a really nice pace, Jenna. My only concern was it sounded like you started out reading. I don't know if you were reading, but it sounded like you were. And so I was kind of like a little put off because when people read, I'm a little concerned that they're not going to be able to be spontaneous. You ended up being spontaneous and you ended up being able to answer the questions spontaneously. So I don't know if you were nervous or what. It didn't seem like you were, but I just want to point that out. I thought you had a really good pace. And I also thought you started out your argument when you're representing a defendant. Nobody wants to say all the good things about your guy. And you started out saying the good things about your guy, you know, that he consulted the guidelines and the medical schedule and all that. And so you kind of brought us back to the person that was being prosecuted. And I thought that was very effective, the way that you did that. So I would just say really good job.
All right, following up on that, you know, I noticed that a little bit at the beginning too. I felt like you weren't quite as directly engaged with us at the beginning as you were as soon as we got into questioning. And I felt like that just felt much better to me. I will confess that, as you know, when I used to be at the U.S. Attorney's Office years ago, and even after trying quite a few cases, I was somebody that felt more comfortable, at least initially. I used to write out every word. I'd write out my whole opening. I would write out my direct. I'd write my questions on cross. I'd even write out my closing. But because I knew at the end I didn't want to read them, I kept paring them down to smaller and smaller bullets so that I still had something I could keep in front of me, but there was just nothing for me to read. Like you know, it was just the words, and it can feel hard to do that at the beginning. But you know, in the end, I mean, what should make you feel really confident is the fact that, again, as soon as we were asking questions, you were in it and you were on it. And everybody's talking about that moment. We talked about it collectively. That single moment, that the response that you had in that argument, I was like, well, drop the mic. There you go. And so that, which was fantastic. I also thought that same thing, your understanding of the record and your ability to be able to respond very spontaneously was excellent.
Okay. And so I'm going to turn it over to Justice Stratton, who will begin talking about Mr. Clark. But I did want to make one comment. I also was in the U.S. Attorney's Office. I was there when Justice Stratton was the public defender for Los Angeles. And I won't go into sort of, I don't know how I was viewed as a prosecutor. I think I was viewed as kind of a softie, but I don't know.
Yeah, you are.
But one thing that I never got used to as a prosecutor, but most prosecutors are very used to, is sort of dehumanizing a criminal defendant. They don't use the name, the defendant, the accused, you know, they dehumanize them. And so the advice from Justice Stratton about humanizing your client, if you're going to get into individual representation, and outside of criminal cases too, if they're involved in a civil dispute where things are getting nasty, to the extent you can humanize your client, and using the name and showing that you're there representing an individual is super important, especially when you're faced with a prosecutor who's trying to do the opposite. So that's just something to keep in mind as you move into practice. With that additional commentary, Justice Stratton, if you wanted to start us off on Mr. Clark.
Okay. Mr. Clark, I was impressed because you seem like a real prosecutor to me. And I have a lot of experience with prosecutors. And when you stood up and you said, I'm Daniel Clark and I represent the United States of America, I thought that was so cool. I really did think that was cool, because just as the defense should be humanizing their client all the time, whenever you can, because you're the only one in the courtroom that's really going to do it for you. You, Mr. Clark, are representing like the United States. And so when you stood up to say that, it was a very, to me, it was a very powerful moment, and it gave to me, it gave you a lot of credibility that you were just like, okay, I'm here and I'm going to do it. On the other hand, it also means though that you can't pull any shots on it. I mean, you have to be like there for justice, and you have to be there also kind of thinking that you're there also to protect the defendant. And so the one conversation that we had among the three of us was you were a little policy oriented, a little too policy oriented. And some of that is just an inexperience with criminal law, because one of the things that is in the criminal law jurisprudence is you are looking for fairness to the defendant. And fairness to the defendant oftentimes means that policy considerations have to take a second place. And so you were a little, you kept bringing us back to policy. And I thought that in a way you were terrific at that, because we would ask you questions about the individual effect on the defendant, and you would say, oh yeah, that's a really good question or whatever. And then you would very skillfully and seamlessly turn it around and get it back to where you wanted it to go. You'd answer the question, but you very seamlessly brought it back to where you wanted it to be, which is all about policy. And it's fine to do some policy, but you just gotta like balance it and make sure that you, even though you're standing there for the United States on behalf of policy and the public good, you're not forgetting how important the defendant's rights are as well. And you can do that balance. I thought you were just really terrific at your turnarounds, and you also had a really good pace. And you also started out for 4 reasons. This is why I'm right for 4 reasons, or this is why they're wrong for 4 reasons. It's such a great way to argue when you just put it out there. I mean, we've read your briefs and all that, but it's a really wonderful time to summarize exactly what it is you want us to do.
So I thought you were great. I agree with much of or everything that Justice Stratton just said. There is a sort of a difference depending on what court you're arguing to about how much you would, in this instance, lean on a policy argument. And this is a mock U.S. Supreme Court, and so those kinds of arguments are super significant and have a lot of traction at that level of court. You might make a slightly different argument, certainly if this came up in a post-trial motion in the trial court, I would ratchet back the policy and speak to that judge in that tribunal in a way that's sort of more tailored to the effect of the law in this particular case. But this is a case that invites a discussion of policy stuff. I thought your use of case law was super effective, really impressive. And I thought, and this sort of relates to laying out your points that you want to reach. Again, when we threw arguments at you, you went very seamlessly back into where you wanted to be. One of the hardest things to do in appellate advocacy is when you get thrown off track in terms of judges raising issues that you weren't going to discuss until the end of the argument, or come in the middle or take you backwards, is getting back on the road you want to be on. All of you did that very well. I thought, Mr. Clark, you were particularly effective with that. I also think of all the arguments that were being made today, this was the one that I just, as sort of a gut reaction, if I were actually deciding this case, I had a lot of problems with there not being a good faith exception in here. And so I thought you had a big mountain to climb. You were very effective doing it. Justice Wise?
Okay, in the same way that I think it's hard to be first, it's also a little bit hard to be last, but for different reasons, because we're all warmed up, and so I think that we had We probably gave you, more questions just for you than we almost did collectively with everybody else, because we just kept coming back at so many of these things. You're really fielding a lot. And I thought you did a terrific job of answering the question. And as Justice Stratton said, trying to get it back to where you wanted to go, even if we were going somewhere else. I thought you had also a very good command of the record. And I think we were right at the end when you were talking about the purpose behind this, and you just sort of threw out there, well, before this was the Harrison Act, and that, like, it's somebody who just, clearly knows what's going on with this. And if there was more time and we had a longer discussion, you'd have more to give us. And so I thought it was, I thought it was terrific. I thought you did a really great job.
Thank you all.
All right. Well, I would like to thank our panelists. This has been a tremendous final round. I have really enjoyed it. Thank you so much for your feedback. It was so insightful. This was a great learning experience for everyone. I always learn something when I watch these as well from the panel. And I do want to recognize the fact for everyone that's watching it and our competitors, that our three jurists, they're working judges. They worked all day and studied this record and the other material sent, and they performed at a very high level as well. I sat through hundreds of appellate arguments in my career, and this is as real of an experience as one gets in terms of the level of questioning and probing and interrogating your arguments. And so I thank the panel for making it a real experience for everyone. It was just terrific. And watch out, I'll ask you to do it again in the future. I also, before we hand out the awards, I want to recognize and thank our two bailiffs this evening, Candace Hart and Zachary Johnson. They were as I mentioned at the beginning, they were finalists last year, and I do thank them for helping the trains run on time for this event, as well as all of my outgoing board members. I want to recognize the fact that all of them started in being in moot court and appellate advocacy on Zoom and never got to compete in person. And I'm sorry that you didn't. And yet you all developed an extremely high skill set that I think will serve you well throughout your careers. And so I want to thank the outgoing board, Jaime Jimenez, my outgoing Chief Justice as well, for making it such a terrific year and coming up with such a challenging and engaging moot court problem. So thank you all for that. Now what I would like to do is announce the awards from this year's competition. So the award for the best brief, the individual that had the highest brief score in the competition this year is Andrew Doty. And maybe he's watching. Congratulations, Andrew, if you are watching the live stream. The best advocate this year is an individual who had the highest combined brief score with the highest combined oral advocacy score in the competition. And that individual is actually here tonight. That's Diego Magana. Congratulations, Diego. And last but not least, our best oralist award this evening. And I don't know who won that. So I would turn it over now to Chief Justice Moore, and you can let us know who is the best oralist this evening.
These are, when we decide cases, there's less arbitrariness than when we decide this. Each one of you is more than deserving of being here. Each one of you is more than deserving of an award for best oralist. They only give us one to hand out. I will also say that the four of you, this experience is what really matters. I was in my moot court finals. I was not the best oralist, but the four of you are tied together like the four of us who argued back when I was in law school. And I'm very thankful for having that experience. But having had to select, the panel has selected Daniel Clark as the best oralist. So congratulations.
Congratulations, Daniel, and congratulations to all four of you. As Justice Moore indicates, he became a justice and he did win best oralist, so there's hope for everyone. And a great congratulations to all of your performances throughout the semester. This has really been a tremendous final round. And in fact, this concludes our events for this evening. Thank you once again to our panelists. Thank you to our competitors. Thank you for everyone at home who's watching. And we will see you next year, perhaps even in person. And that would be terrific. Thank you and good night, everyone.